Thank you very much, Avis. Good afternoon, ladies and gentlemen. It is my pleasure and honor to be here today. This event is of crucial importance for me. From the day of my appointment in December 2016 last year, it was my intention to visit Kosovo and to hold such a meeting with representatives of the social society. These are the reasons for my presence here today, namely to provide a detailed update and clear information about the work of the Kosovo Specialist Chambers and to answer questions that you may have. Today's event is of vital importance in order to achieve a great understanding of the mandate and the work of the Specialist Chambers. Second, to establish trust in the judicial process before the Specialist Chambers. To demonstrate that the Kosovo Specialist Chambers are dispensing justice impartially and independently, free of any influence and interference, fear or favor. At the outset, I would like to firmly state the following. The Specialist Chambers have been established to address allegations of grave human rights violations amounting to crimes against humanity and war crimes by ensuring fair, safe, independent and impartial trials. The mandate of the Specialist Chambers is to prosecute and try cases against individuals and not against organizations or ethnicities. Third, the Specialist Chambers strive for efficiency, transparency, and neutrality. Fourth, and most importantly, the Specialist Chambers respect and endorse equality for the rights of victims, witnesses, as well as for suspects and accused. I would like to make a brief retrospection on the establishment of the Kosovo Specialist Chambers. As many of you may know, in January 12, 2011, a report of the Parliamentary Assembly of the Council of Europe was issued alleging crimes committed during and in the aftermath of the Kosovo conflict for the period 1998, 1st of January, till the end of 2000, 31st of December. In May the same year, 2011, the Special Investigative Task Force was established to further investigate allegations of unlawful detention, deportation, torture, killings, and other crimes related to the Council of Europe report. In 2014, in 3 years, Mr. Clint Williamson reported the results of the Special Investigative Task Force investigations. In the exchange of letters between the European Union and Kosovo in April 2014, the cornerstones of the Specialist Chambers were laid down. Kosovo suggested, in these exchange of letters, to set up a relocated judicial body to investigate, prosecute, and adjudicate crimes deriving from the Special Investigative Task Force investigation. It was also agreed that dedicated, separate judicial chambers would be relocated to a third state, that sub-judicial chambers would be governed by their own statute and their own rules of procedure and evidence, and that they would be staffed with international staff only, and the judges will be international judges. The exchange of letters was thereafter ratified by the Assembly of Kosovo. The framework for the setting of the Kosovo Specialist Chambers, as agreed in the exchange of letters, was implemented and further specified in the amendment to the Constitution, Article 162, as well as by the adoption of the law on Kosovo Specialist Chambers and Specialist Prosecutor's Office by the Assembly of Kosovo on the 3rd of August 2015. The law on the Kosovo Specialist Chambers and Specialist Prosecutor's Office created the Specialist Chambers, which is composed of two organs, the chambers, comprising of judges, tasked with the judicial work, and the second organ is the registry, with a complex structure to administer and service the specialist chambers, namely the judicial work of the specialist chambers. The law also established the Specialist Prosecutor's Office as an institution absolutely independent from the specialist chambers. The Specialist Prosecutor's Office is the driving force of the investigations and prosecutions of the crimes under our jurisdiction. It is separate and independent, as I said, from the specialist chambers. And the specialist chambers, as long as judicial proceedings wouldn't commence, has nothing to do with the office of the prosecutor. We do not have any powers in this regard. A planning team tasked to set up the initial structure of the specialist chambers as a relocated institution, headed by Dr. Fidelma Donlon, commenced its work in 2015 in Brussels. In April 2016, Dr. Donlon was appointed registrar of the specialist chambers, and in September, the 1st of September, Mr. David Schwendeman was appointed specialist prosecutor. Following a robust assessment of all candidates' expertise in the legal field, the independent selection panel recommended to the appointing authority 19 judges to the roster of international judges and myself. I was appointed on the 14th of December to the position of President of the Specialist Chambers, which is an enormous honor, but at the same time an enormous responsibility. And I assumed office on the 12th of January this year. On the 1st of January 2017, the host state agreement with the Netherlands was entered into force, was signed between the Netherlands and Kosovo, which allows for the conduct of proceedings on the territory of the Netherlands. What is the performance so far of the Kosovo Specialist Chambers? In March this year, in less than 2 months of relentless drafting with my small legal team, the team of 3 persons, and following the comments and proposals of judges, we have conducted our first plenary, which adopted 3 seminal documents. The first one was the Code of Judicial Ethics, establishing the principle and standards that judges have to respect and to abide by in their judicial performance, and in case of violation, not adherence to these internationally recognized principles and standards for the performance of the judicial profession, there is a provision about disciplinary proceedings that could commence, ending up with sanctions, the most hardest one being dismissal from office. So by adopting this Code of Judicial Ethics, judges demonstrated their professionalism and their readiness to abide in the judicial proceedings and their performance by well-established worldwide standards of the judicial profession. The other document was the rules on the assignment of judges to specific cases as soon as we are going to be seized by the prosecutor. And the most important document still was the rules of procedure and evidence, which in a domestic system could be translated as the Criminal Procedure Code. The rules of procedure and evidence have been thereafter, after adoption by the plenary, which was on the 17th of March, were thereafter subject, according to the law, and according to the constitutional amendment, they were subject to the review of the Specialist Chamber of the Constitutional Court. And for all those of you who are interested in our performance and activities, you know already something that I will still repeat, that out of 208 rules of the document that was adopted by the plenary of judges, the Specialist Chamber of the Constitutional Court found that 9 were not reaching the highest standards of human rights, and they were reversed and turned back to the plenary for further work on these 9 rules in order to be in full compliance with Chapter 2 of the Kosovo Constitution and with the highest human rights standards. Thereafter, there was also a review by the same specialist constitutional chamber, and after the review ended up positively, the specialist chamber judges being content, satisfied with the final result, the rules of procedure and evidence entered into force on the 5th of July this year. So as of this very date, the 5th of July, the specialist chambers are fully operational, and we are ready since then to start judicial proceedings if seized by the prosecutor. I would like very shortly to inform you about the selection of judges. The selection of judges is a novelty which is provided in the law for the Kosovo Specialist Chambers and Specialist Prosecutor's Office as adopted by the Kosovo Parliament. It was conducted, the selection process, by an independent selection panel comprised of 2 international judges with substantial international criminal justice experience and 1 high-positioned lawyer representative of the European External Action Service. I have to say that if you are to compare with other institutions that are dealing with the same crimes, crimes against humanity and war crimes, the selection panel was provided with ample opportunity to decide on the merits of the candidates, their expertise and their commitment to justice, because the relevant state parties of the European Union and contributing states shouldn't nominate candidates for the roster of judges. They have just to support those who would like to apply, meaning that these are well-established professionals and everything that is reflected in the application form is truthful, and that is how the legal society of the relevant country views these applicants. Thereafter, it is for the selection panel to take its independent decision. And, for example, there was no one nomination from one country when back then in 2005 and 6 I was nominated. I was the only nominee from my country, as is the case with anyone who was a nominee of the relevant state parties to the Rome Statute for the International Criminal Court. In this case, there were a number of judges. For example, I was told today, I thought that the number was a little bit more, but 9 judges applied from Germany. Then 17 applied for Italy. From my country, we were 5. I knew only one of them. But on the roster, we do not have just one representative from each country, because the selection panel assessed the expertise, the experience, the knowledge of all applicants, and now we have 2 French judges, 2 judges from the Netherlands, 2 Italian judges, we have 4 from Germany, we have 1 from Norway, 1 from Ireland, from UK, and so on. So this is a demonstration that this vigorous vetting process that was conducted by the selection panel had to result in a high caliber of professionals that are truly committed to the rule of law and to the interests of justice. So the application process also deserves a little bit of attention. The judges who applied had to undergo a kind of an assessment at the national level. That was the first level. And then there were two different interviews. The first one was conducted before the selection panel in Brussels, and the second one was conducted in The Hague again. And it was, I can assure you, this was a real serious exam with regard to many different issues related to the law, and not only to the law, but how those who would like to apply feel about their absolute total commitment to justice. So now on the roster, we have judges of high moral character, impartiality, integrity, and that was demonstrated. I would like to disclose to you something, so to say, from the kitchen. When we were working on the rules of procedure and evidence and the other two documents, we had first remote work on behalf of all judges, working on the drafts that I, with my small team, we have provided to them 10 days after they were put on the roster. Thereafter, we conducted a 4 days first plenary. And it was so impressive that judges they were listening to each other. No one was obsessed by his initial approach, by his or her initial proposals made in this circulation of provisions and of proposals that were made to me in order to be reflected in the drafts. We were all striving to achieve the best results, bearing in mind, of course, lessons learned from other institutions dealing with the same crimes, and also trying to find the balance between the expeditiousness of proceedings, but also the fairness, the equality of arms that have to be provided to anyone. And if you would ask me questions, I can give you a lot of examples about these results. Now, with regard to some important points that were reflected in our rules of procedure and evidence. First, the fairness and expeditiousness, which is a principle that has to be adhered to, and there is ample of judgments with European Court for Human Rights against states, condemning states for not respecting the expeditiousness of proceedings and also fairness of proceedings. Of course, here I would like just to point out something which is essential. Most of the judgments condemning states are for delayed proceedings, for violating the reasonable time standards. But also there are some very limited number of cases whereby states have been condemned for being too expeditious, so expeditious that the defendant was deprived of all the opportunities that a fair trial has to present to the person. So that's why we try to find a good balance between these two vital principles in the proceedings. So we have established strict timelines for the investigation and detention. For example, a detention has to be reviewed every second month by a judge. Then if a person is held in the position of a suspect, and in comparison to the position of an accused person, the accused enjoys much more rights than a suspect. That's why it has been provided that the person, after the expiration of a time, that the person would start feeling uncomfortable with these extensive proceedings, without the prosecutor bringing an indictment, the person could approach the president. The president is going to appoint a single judge and to address these concerns that proceedings are without any good reason delayed, and the person has the still limited rights of a suspect. Then it will be for the single judge to decide upon discussions with the prosecutor, of course, going into the courtroom. And if the prosecutor wouldn't be able to come up with an indictment, and there are no justifiable reasons for the standing, for the situation of the suspect, then the judge could terminate the proceedings. So also if proceedings are unduly delayed and the judges are going to find out that this is again due to a behavior on behalf of the prosecutor that is not well justified by some good reasons, then upon discussions the chambers could also approach this very radical decision to terminate the proceedings. Then I would like shortly to address the issue of witness protection and participation of victims, because I wouldn't like to take much of your time in order for you to be able to ask all your questions, because it is maybe much better to go into a vivid exchange. With regard to the witness protection, this is of utmost importance for any institution where the life, safety and security of anyone having a standing before the chambers is cherished and is taken care of. We have been very much aware of the issues that are faced by witnesses, be it at an international or domestic level. And that's why this is pivotal for us to take measures. And of course, I will just mention those that are typical for a number of international statutes or domestic legislation, like using pseudonyms, also redacting information that can disclose the identity of the person who is appearing as witness, also conducting closed session proceedings for a particular part of the proceedings where this identity could be disclosed, private sessions as well, also a robust witness protection program where we are, and that I cannot disclose to you because then the whole idea of witness protection is going to be totally senseless. Then I would like also to refer to the following. Under our jurisdiction, apart from crimes against humanity and war crimes, fall crimes against the administration of justice, meaning that anyone who would decide to intimidate witnesses or to bribe, to prevent witnesses, or to let alone to create some problems for the witness or for the members of his or her family, it is not possible. The prosecutor is obliged to start immediately an investigation. And this could be also an investigation against the accused brought to justice. So in addition to the main charge for crimes against humanity or war crimes, the person could face charges for crimes against the administration of justice. Then the chambers also have quite a lot of powers. If, for example, the person has been summoned to appear, and it comes to the knowledge of the chamber, and I have been experiencing in my previous capacity quite a lot of situations of this kind, then the chamber can, if the person is summoned to appear, the chamber can take a decision for an arrest warrant that is subject to the immediate enforcement, be it by the relevant authorities of Kosovo or by the special police of the prosecutor and so on. Then, in the detention unit, everyone who is in the detention knows that people are constantly under the so-called passive monitoring. And of course, you know that the right to privacy when meeting family members, when meeting the counsel, or someone who is a person helping with the religious beliefs of the detainees, is going to, they enjoy, of course, the secrecy of these meetings. But if it would come to the knowledge of the chambers that this is misused, and the actual purpose of these meetings is to start targeting witnesses, for example, then the chamber can take a decision and the registrar will switch into active monitoring, which could end up in, again, in a case, in charges for crimes against the administration of justice. So for the moment, I can tell you as much as I said about the witness protection. Participation of victims is a novelty. There is at the ICC this victims' participation scheme, but it's somewhat different. There is within the registry, but the registrar is going to speak about this victims' participation office. Victims have the right of notification, acknowledgement, and reparation. Chambers that are going to issue a final decision, for example, convicting a person, could also issue an order for reparations against the convicted person for individual or collective reparations. And this Office of Witness Protection has to provide support and assistance to victims of the crimes that fall under our jurisdiction and that are included in the indictment as confirmed by the pretrial judge. You know, and this is the last point that I'm making, that on the 6th of November, we have put, the registrar put on the website of the Kosovo Specialist Chambers, the Directive on Counsel, whereby the requirements for someone, for anyone who would like to end up on the list of counsel and to be able to be appointed or assigned as counsel in the proceedings before the specialist chambers, all these requirements are put in this directive for counsel. Of course, the requirements are quite strict and quite high. Why? Because the purpose is to provide the best possible support and assistance on the part of those counsels that are going to appear before the chamber. Also, there is, and it will come quite soon, we are working on legal aid regulations. I know that the Parliament of Kosovo has enacted a law on legal aid for the protection of those and their members of their families who might potentially be accused in the proceedings before the specialist chambers. But apart from this, and this is a very good approach in a lot of domestic systems that cherish the right for proper representations, this is a legislation that has been enacted. But apart from that, we also are working on legal aid regulations for those who are fully or partially indigent and cannot afford themselves to pay for a counsel. The outreach, maybe I will just announce a very important pledge that was made by the Swiss government for 2 years, very robust outreach program that is going to give us the opportunity, and we are very grateful, to start working with the social society and meeting representatives of the social society in order to be able to explain everything that is of concern to people who are interested in our functioning, also to avoid any misunderstanding about the nature, about the mandate, about the crimes that fall under our jurisdiction, so that we are faced with expectations that fall within the mandate as was assigned to the Kosovo Specialist Chambers by the members of the Parliament that enacted by 2/3 majority the law on the Specialist Chambers and Specialist Prosecutor's Office. Now, I will end up by saying that I'm reiterating, I was honored to be appointed to this position, but at the same time, it is really a tremendous responsibility. I hope that in this position, I will not face situations where, for the first time in my professional career, I will not feel comfortable to meet you in several months, to face you, and to honestly, sincerely, and with the dignity of my profession to respond to all your questions. At the end, I will make the following points. We would like to ensure that the specialist chambers be seen as a beacon of independence, impartiality, and fairness, that we are not going to be tainted by any influence, interference, and political agenda. Judiciary doesn't go with politics. So if someone would be of the view that this could be achieved, the Kosovo Specialist Chamber judges are not the proper addressees of this. And that we are going to be a sterling safeguard for the security and safety of witnesses, and victims, as well as for the fundamental rights of the accused. So I will end up here, and I'm open for any questions that you might have with regard to what you have seen so far on our side. But just to make it clear, because I have been following the press, and there are some views that I'm coming because there are indictments. With all honesty, there are no indictments. For the moment, we are still on hold. We are waiting for the prosecutor to perform his duties. As in any system, the prosecution's office is the driving force. So I came because I wanted, after we have finished the most important task, to establish the legal framework for the functioning of our institution, making it operational and functional, to come and to meet you. And that is going to be my approach in the months to come, whenever there is a need to come and to face you. Thank you very much.